5 seconds to go. Start. It is a matter of record that presently, in almost all the pending disciplinary inquiries, most of the employees under inquiry are now asking for retired officials to act as DRs. It is submitted that aforesaid aspect has not at all been considered by the High Court while permitting the respondent employee to allow ex-employee as his DR. Making the above submissions, it is prayed to allow the present appeal. Learned counsel appearing for the respondent had submitted that Regulation 44 of the Regulation 2020 do not bar engagement of retired employee of the bank to act as a DR. It is submitted that the only bar under the rules and the regulation is with regard to appointment of legal practitioner as a DR without permission of the bank. It is submitted that therefore the High Court has rightly directed the bank to permit the respondent employee to avail service of the retired employee of the bank as defense representative. It is submitted that Handbook of Vigilance Administration and Disciplinary Action dated 15th March 2019 are not binding rules or guidelines and are merely directory in nature. It is submitted that on conjoint reading of clause 7.2 and clause 8.2 of handbook procedure would mean that only officer who is junior to the presenting officer and inquiry officer can be appointed as DR. It is submitted that this would result in gross miscarriage of justice and in violation of principles of natural justice. It is submitted that judgments cited by the learned counsel for the appellant shall not be applicable to the facts of the present case, as every bank has its own rules and regulations. It is submitted that in the present case there is no specific bar in the service regulation in engaging retired employee of the bank as defense representative. It is submitted that therefore in absence of any specific bar and considering the regulation 44, the High Court has not committed any error. It is submitted that similar question came up for determination before the High Court of Allahabad in the case of Rakesh Singh versus Chairman and Disciplinary Authority and another in writ appeal number 64711 of 2013, wherein the High Court has held that in absence of any specific bar in the regulation, the denial of the right to engage a retired employee of the bank as defense representative is not justified. It is submitted that said judgment of the Allahabad High Court has been affirmed by the court and the SLP against the said judgment and order has been dismissed. 2010 neither restricts nor permits availing the services of any outsider and or ex-employee of the bank as DR, and to that extent regulation is silent. If the reasoning of the High Court is considered, the High Court is of the opinion that as there is no complete or absolute bar even on engaging a lawyer, it is difficult to accept that a retired employee of the bank cannot be engaged to represent a delinquent officer in the departmental inquiry. Stop.